Great. Thank you all for being here and welcome. My name is Laura Dobbs, and I'm an attorney here at the Virginia Poverty Law Center. And with me is my colleague, Steve Fishbach.
Hi, I'm Steve. I'm the litigation director at the Poverty Law Center.
We're a statewide organization, and we work on breaking down systemic barriers to poverty in Virginia through advocacy, education, and litigation. And tonight we're going to go over what is fair housing, what is covered. We'll go over some particular rules related to the source of funds protections, as well as fair housing and how they might relate to immigrant rights. And finally, how do you enforce the Fair Housing Act? And so the starting point is like, what is fair housing? I think so often we hear this concept that, oh, fair housing just means treating everyone the same. And that's not quite it. It's about this fundamental belief that all people should have the right to live where they choose, free from discrimination. It first originated with the Federal Fair Housing Act that was passed in the 1960s as part of a suite of other civil rights litigation. In that original form, it was to stop discrimination in both the sale, the rental, and financing of housing. And when it first passed, it covered only a few protected classes, but it has since expanded to other protected classes that we'll go over in a bit. And then there's also the Virginia Fair Housing Act. Now it's pretty similar to the Federal Fair Housing Act, but it has some additional protections. Again, we'll go over that in just a little bit. To understand like what the Fair Housing Act is about and who it protects, I think it's helpful to break it down into some basic elements. So in a housing transaction, it is illegal to discriminate against people because of their membership in a protected class. So those are the four basic elements of what fair housing covers. And I'll turn it over to Steve.
Thanks. So diving into what is a housing transaction, they're pretty straightforward, although there are some that are covered that you might not think of as a housing transaction. So renting or buying a home, obviously, getting a mortgage, seeking housing assistance from housing counselors and brokers. Then there's some that you might not think of, like community development activities, such as the demolition of housing units or big chunks of neighborhoods. Certain zoning decisions might also run afoul of the Fair Housing Act. Code enforcement activities. In other words, a city's enforcing laws. Are they enforcing them everywhere the same, not the same? Those might be covered. And engaging in other housing, related activities more generally. Next slide. So what kind of properties are covered? Again, this is pretty straightforward, although as we get towards the bottom of the list, it may sort of surprise you. So obviously, apartments where people rent, houses or condominiums that people buy, mobile homes where people either rent or buy, shelters for the homeless or for others like domestic violence victims, those will be covered. Nursing homes are covered. Group homes are covered, as well as the sale of vacant land. And again, next slide. So there are certain exemptions in the Fair Housing Act. So for example, sales of single-family homes without the use of a real estate broker or an advertisement, those would not be covered. An owner-occupied building with 4 or fewer units are not covered. Housing for older persons, again, this is mostly for familial status discrimination. so that housing can be reserved for older people, and also religious, I don't know what you mean by private here, but religious properties are also exempt.
So for that second element, getting into what does discriminate mean? It can mean a bunch of different things, including refusing to rent or otherwise make available. It can mean, giving some people different terms and conditions than others. It could also be just outright discriminatory statements, that sort of, red hand of obvious discrimination or bias. But it could also be misrepresenting availability of a unit, such as if a tenant is applying for an apartment and the landlord lies and says, "Oh, we don't have any units available to you." And there's blacklisting, which is a lot of what I think the Fair Housing Act was meant to put a stop to, which was realtors would go into white neighborhoods, and this is where the whole white flight scenario came into play. Realtors would scare the white family into selling the property at a lower price and then turn around and sell it to a black family at an inflated price. And it could also include the interference or coercing someone or intimidating and retaliating against someone who's trying to enforce their fair housing rights. So just a basic definition would be the less favorable treatment of a person or a group of people based on certain characteristics for people who are in these protected classes. And so what does this look like? It could require a renter to pay a higher security deposit just because they have kids, or refusing to rent to someone because they're Muslim. And here we have the example of blockbusting that I talked about, of the real estate company convincing a white family to sell their home at a lower price, citing fears of immigrants moving into the area and then turning around and selling those homes at an inflated price. It could also be lying and telling a voucher holder that there aren't any apartments available to rent, even when there are.
So one thing that we failed to mention at the beginning is that if you have questions, feel free to type them into the chat. That way, either we can come to them at the end, or if it's something that's where it might be easy to answer as it pops up on our screen, we may choose to answer it then. So, feel free to use the chat to ask or questions as we're going through this. So the next element is because of, and here's where we try to break it down into what what types of discrimination there are. So the first one is intentional discrimination, purposely treating people less favorably. So I won't rent to women. That's pretty clear. That kind of a statement is indicative of intentional discrimination. Then there's also a doctrine called disparate impact or discriminatory effect. So that would cover like a neutral policy that might negatively affect certain protected classes more than others. So, for example, and we're gonna come to this later, a requirement that you have a job to rent an apartment, that you have to have employment income in order to rent an apartment. That would have a disparate impact on disabled people who might be on some form of public benefit or public assistance. So, and they may still have enough money to afford the apartment. So that's what disparate impact covers. There are also certain affirmative requirements that housing providers must abide by under the Fair Housing Act.
No,
and that's
behind me.
and that's the concepts of reasonable accommodation or modification, which is a reasonable accommodation is a change in a housing provider's policies to accommodate a disabled person. So, for example, a disabled person might need to have grab bars in a bathtub. So the tenant could request permission to install them, and the landlord would have to agree, essentially, because the Fair Housing Act requires housing providers to allow for those types of reasonable modifications. Next slide. And this was the, I'm sorry, I want to just go back to our 4 parts, because I think this is the last one. Because of their membership in a protected class. So what is a protected class? Well, first of all, pretty much everyone is covered by the Fair Housing Act, because everyone, for example, has a race. Everyone, for example, has color to their skin of some sort. As the slide notes, there are certain protected classes that are only federal, and then there are other protected classes that are both federal and state under the Virginia Fair Housing Act. So again, the federal ones are race, color, religion, including folks who don't have a religion, national origin, sex, which includes sexual orientation and gender identity, disability, and familial status, meaning a household with children under the age of 18. That's what familial status refers to. Then we have the Virginia ones, which include gender identity, elderliness. I'm not sure what age it is. I just don't know right off the top of my head. Sexual orientation. Then there's source of funds discrimination, which we're going to go to in a little bit of detail. And also in Virginia, people in the military are covered.
So to give some examples of what fair housing discrimination looks like, this is one of intentional discrimination. So here, the Yao family has 2 small children, and they decide to apply for a 3rd floor apartment with Lenny, the landlord. Lenny says that he cannot rent to them right now because he has a policy against having kids live in 3rd floor apartments, because he, in his own personal opinion, thinks it's unsafe. And he doesn't have any other apartments available. Here, Lenny has discriminated against the Yao family based on their familial status, and this would be a fair housing violation. It's not up to Lenny, the landlord, to tell the Yao family what they should do for their children, nor is there any the occupancy standard saying that kids can't live there. And so this way, he has discriminated against based on familial status.
And I already sort of covered this, but I'll go through it again. So in this situation, Lenny, the landlord, has a policy that he will not rent to anyone who does not have a full-time job. Sam, who is a retired disabled veteran who has enough disability income and savings to afford Lenny's apartment, applies for the apartment, but Lenny denies the application, citing his policy that tenants must have a full-time job to rent his apartment. So Lenny's policy is not to rent to applicants who lack a full-time job disproportionately affects disabled applicants, as I mentioned earlier, as well as elderly and formerly military applicants, and potentially also the applicant's source of income. So the disabled one is the Federal Fair Housing Act, and all the others come under the Virginia Fair Housing Act, and they would probably constitute violations.
And so for an example of fair housing discrimination based on failure to make a reasonable accommodation would be Janet, she's visually impaired and she relies on the assistance of a seeing eye dog in order to get around. She applies for an apartment with Lenny, the landlord. However, Lenny, the landlord, has a strict no pet policy. He says, I treat everyone the same. I don't let anyone have pets. And so because Janet insists on having a pet, he refuses to rent to her. Janet asks Lenny if he can make an exception to the no pet policy because she needs her seeing eye dog to get around. However, Lenny insists he refuses to modify his policy or grant her an exception. In this way, Lenny has discriminated against Janet based on her disability, and this would be a fair housing violation.
A separate violation of the Fair Housing Act is when a housing provider retaliates against an individual who's tried to secure their rights under the Fair Housing Act. So even if the underlying complaint lacks merit, if the landlord took a retaliatory action against the tenant, or if the housing provider or seller retaliates, even if the underlying reason would not technically constitute a violation of the Fair Housing Act, retaliation is in and of itself a separate violation. So that's important for people to know, because if they do file a complaint and something else happens, they can further vindicate their rights, even if their original complaint lacked merit. So what are examples of retaliatory conduct? Threatening to report a person to the police or to ICE, threatening to evict a person, increasing their rent, decreasing services. However, a landlord could still evict a tenant who filed a fair housing complaint if the tenant is behind in their rent, or if the tenant stays over, in the apartment after the lease ends. And a landlord can increase the rent up to what a fair market rent is, and decrease services too. But if the service decrease has to apply to everyone, not just to the person who filed the complaint.
So I wanted to get into some specifics related to the source of funds protections. It was added back in July, well, it became effective July 1st of 2020. So it's still pretty new here in Virginia. And there are some particularities to it that I want people to understand. So under the Virginia Fair Housing Act, it defines source of funds as any source that's is paid on behalf of a renter or a buyer of housing, and it include any assistance, benefit, or subsidy program, whether that program is administered by a governmental or non-governmental entity. Despite some of the popular conversation around it, it includes not just the Housing Choice Voucher Program, which is where you might hear it referred to a lot, but other types of benefits as well. This can include, disability benefits, veteran benefits, rental assistance, such as the Virginia Rent Relief Program. If someone's receiving money from child support or from alimony, that would also count, as well as, depending on where a person is getting a mortgage in order to purchase a home. So it's not limited to just one thing. It's any government or non-government assistance. So there are a few different types of discrimination it protects against. It protects against refusing to rent or sell based on someone's source of funds. So based on how a tenant is going to be paying their rent. It also prohibits imposing different terms, conditions, or privileges of the sale or rental of that person's dwelling based on the source of funds. It also prohibits that outright discrimination of placing advertisements that express a preference or limitation. For example, a landlord can't advertise an apartment and says, does not participate in the voucher program. That itself is a form of discrimination. And it means that they cannot represent that a building is unavailable for sale or rental based on that person's source of funds. So like an example I used earlier, if a landlord is showing an apartment to someone with a voucher, they can't say, oh, well, we just had another applicant come in and this is no longer available, despite that not being true. That would be a form of discrimination. Now, there are some exemptions to this particular protection. I know there's been some concerns of how is a tenant supposed to prove that there's been this discrimination, but it's not on the tenant to prove that. Whoever it is that is saying that they're exempt from this law, they have the burden to show that they're exempt from this. So who is exempt? It exempts landlords who own 4 or fewer units. The term units is very important because it's not just apartment buildings, it's how many apartments are within that building is what counts. So they're allowed to limit occupancy depending on that person's source of funds. However, this doesn't apply if a landlord owns a 10% interest in more than 4 units. So this is trying to make sure we're getting at those investors who might have a stake in a whole bunch of different properties. They're not exempt under this rule. And then a further limitation on this is that a landlord can deny housing based on that person's source of funds if they're not approved within 15 days of when that tenant makes a request for approval. This in particular is getting at someone who has something like a housing choice voucher. Once they identify a place, they have to get that unit approved through the agency that issues the voucher. The voucher authority will do an inspection of the property, make sure that it's within their fair market rents that they will cover. However, even though there's that 15-day turnaround to get that approved before the landlord can just back out of the whole process, that 15 days is dependent on when that request for approval is made. Whether it's mailed, emailed, or delivered to that voucher administrator. And the landlord has to participate in good faith. They can't set up arbitrary barriers to delay the process or postpone submitting the approval or postpone that inspection that artificially makes it past that 15 days. For example, if the housing authority has been trying to do the inspection and the landlord keeps on not showing up to unlock the doors, intentionally dragging it out so they get past that 15 days, that's not allowed. They're not exercising good faith. Therefore, they shouldn't get the benefit of backing out after the 15 days. So there's a question is like, I know there's some landlords who don't accept Section 8. How do they get away with that? I think there is still a lot of illegal discrimination going on in Virginia, unfortunately. This is still a relatively new policy. Now, there are probably some landlords out there who are in fact exempt. However, if they're advertising the discrimination, I would say that's still illegal. And so just to give an example of what the intentional discrimination with a source of funds would look like. So in this scenario, Michelle lost her job during the pandemic and she's struggling to keep up to date on rent. So she applies for the Virginia Rent Relief Program in order to pay her next 3 months of rent. However, Michelle's landlord, Lenny, who owns 8 units, therefore he is not exempt, he refuses to cooperate in completing the rent relief application and insists that he does not participate in government programs and he doesn't want the government's money. With the assistance of a rent relief navigator, Michelle is still able to complete that rent relief application without Lenny's involvement.
It's
However,
frozen.
I'm sorry. Am I unfrozen now? Am I still frozen? No? Okay. I'm sorry if it's frozen on your end. Hopefully with the recording later, you'll be able to see. Okay. I'll pick up back in the example. So with the rent relief navigator, Michelle's able to get that application submitted without Lenny's involvement. However, when the check arrives, Lenny refuses to take it. He doesn't want to accept the money. Here, because Lenny has refused to cooperate with that rent relief application, and because he refused to accept the money from the rent relief program, he has committed a source of funds discrimination. So that is 2 separate instances of a violation of the Fair Housing Act here in Virginia. Now, the second example is looking at how this might be a disparate impact discrimination specific to the voucher program. So here, Lenny requires that all tenants, regardless of where their rent money comes from, to have an income that is 3 times the monthly rent amount. He's only charging $1,000 per month for rent. Therefore, tenants have to have an income of at least $3,000 per month. Alice makes $800 a month, and she has a housing choice voucher so that she only has to pay 30% of her income towards rent, which is $240. The voucher will cover the remaining $760 of the rent amount. Now, when Lenny goes to calculate Alice's income, he adds her income, the $800, to the amount of voucher she's getting, so $760, for a total of $1,560. Because she doesn't make 3 times the amount of rent, Lenny refuses to lease to Alice, saying that she doesn't meet the income requirements. This method of calculating her income discriminates against voucher holders and would violate the Fair Housing Act. When a landlord is looking to see if a voucher holder meets the income requirements, he should only be looking at the rent based on how much the tenant is responsible for paying. That voucher amount, that $760 that the voucher covers, it isn't additional income from Alice. It is a benefit that is coming from the issuing authority straight to the landlord. Lenny should only be calculating her income relative to how much rent she is responsible for paying. I think this is probably one of the most common examples that we're going to be seeing of voucher discrimination across Virginia.
Sorry, I had myself muted during Laura's presentation because I knew she was going to talk for a while, and now it's my turn to talk for a little bit. So I'm going to cover fair housing issues that affect people who are immigrants or recent immigrants to this country. Next slide. So fair housing laws apply regardless of immigration status. In other words, someone who's in this country illegally can claim that they were discriminated against and seek protection. However, immigration status is not a separate protected class under the state or federal fair housing laws, but the protections apply that relate to immigrants include race, color, national origin, and religion. Those, those are the way that you would frame a discrimination case for someone who is a recent immigrant. Next slide. So here are some examples of unlawful discrimination that are experienced by immigrants. The refusal to rent, sell, or even negotiate a housing transaction because of that person's birthplace, ethnicity, or ancestry. Charging additional rent, an additional security deposit, or other charges because a person speaks a language other than English. Discouraging or recommending that certain communities, discouraging or recommending that a person choose certain communities because the home seeker has a name that may be associated with a particular national origin. And refusing to make repairs or properly maintain a dwelling because a person is an immigrant or a refugee, while providing repairs and maintenance to everybody else. Next slide. More. Requiring social security numbers, proof of lawful immigration status when you have a foreign sounding name, or based on the person's appearance or accent or form of dress. Requiring all household occupants to speak English. Telling a person not to cook certain foods because of odors. Forcing a person to choose an apartment near other people who speak the same language. And enforcing certain rules against someone, but an immigrant, but not enforcing those rules against anyone else. Those are all examples of unlawful discrimination under the Fair Housing Act. Next slide. Hold up, gotta move this. Okay. So, this applies actually to any type of discrimination, not just to discrimination against immigrants. If you are a victim or if you're advising someone who has experienced discrimination, here are some useful tips. They should keep a record, a written record of any incidents of discrimination. And that record should have a lot of information, names, dates, addresses, rental terms, or whatever else is, the subject of the discrimination. Keeping any documents related to the discrimination, including emails and text communications, photos or recordings. Using screenshots of text messages is a really good way of, of documenting discriminatory conduct. And contacting a fair housing organization to see about arranging a fair housing test. And I'm going to go into that a little later in the presentation. Next slide.
Well, I just want to insert another tip here that we didn't include on this, and that's to talk to your neighbors to see what they've been going through. I'm thinking in particular context of what we've been hearing in situations where tenants have relied on rental assistance to try to pay their rent during the pandemic. And now landlord is switching them from a month-to-month lease or refusing to renew their lease. Determining whether or not there is actual discrimination there is going to greatly depend on knowing whether or not that landlord is treating those tenants differently from tenants who did not get rent relief. And to do that, you have to talk to your neighbors to see if they're going through the same thing. If they, were able to keep hold of a job and didn't have to get rental assistance during that time, and yet their landlord just went ahead and renewed their lease, no questions asked, it's quite possible that there's a source of funds discrimination going on there.
And talking to your neighbors, you should write down what they say, because it may be important later to get a written statement, and it would be useful to capture that person's thinking when they tell it to you, because of sometime later there's the need to get a written statement. There'll be something of a contemporaneous record that might be very helpful to the person that you got the statement from initially. So I did make a reference to testers and testing. So it's a very important way to prove discrimination against an individual. In other words, what's done with a test is you try to recreate the same situation that constituted the discrimination, but substituting someone with different characteristics. So, for example, if a Latinx person is told that an apartment is not available, you would have a white person or potentially even a Black person make the same contact and see if they come up with the same result. Because when people are treated differently, and that is what discrimination, unlawful discrimination is, different and less favorable. So if the Latinx tenant is turned away, they're losing an opportunity, a housing opportunity. Whereas if the white or Black person is not turned away, that shows that the Latinx person was treated differently and disadvantaged by the person doing the discrimination. So in our example here, a tester may call Lenny the landlord, pretending to be someone looking for an apartment to rent, and the tester asks Lenny if they accept vouchers. And if Lenny says no, the tenant has collected evidence that Lenny may have committed a fair housing violation. Sometimes this is done repeatedly, again, to gather more evidence. So testers too can actually seek enforcement of fair housing laws. So if a tester, again, in this example, the tester who doesn't have a voucher and is really not even looking for an apartment calls Lenny and says, "Hey, I want an apartment, and do you take vouchers?" And Lenny says no. The tester actually could file a discrimination complaint. And below we listed two organizations that do testing. One is Home Housing Opportunities Made Equal. They're based here in Virginia. There's the other organization, Housing Rights Initiative, is not local, but they have done some work here.
So for actually enforcing those fair housing rights, there's a few different options. The two main ways are you can file an administrative complaint or you can file a lawsuit. The administrative complaint, you can either do it with Housing and Urban Development HUD for any federal violations, or you can do it in Virginia with the Department of Professional and Occupational Regulation, otherwise known as DPORT, for any state violations. If you're going to go the administrative complaint route, you have to do that within 1 year of the violation. And for filing a lawsuit, for federal claims, you can file in federal court. If it's a discrimination based on the Virginia Fair Housing Act, you can actually file in state or federal court. And you have 2 years after the violation to file your claim.
Just one point as to what Laura said, just a slight caveat. You can file a lawsuit alleging a violation of the Virginia Fair Housing Act in federal court only if you also have a violation of the Federal Fair Housing Act or some other federal law. Right. So just a slight correction to what Laura said. So here is how you would go about filing a federal complaint. The federal complaint is filed with a federal agency called the U.S. Department of Housing and Urban Development, more commonly known as HUD. And HUD has, under the Fair Housing Act, the enforcement powers to receive, investigate, receive and investigate complaints and make findings and potentially, we'll get into the process in a second, but the important thing, at least for right now, is knowing the information as to how to file a complaint. And you can do it online, you can send an email, you can call in complaints or mail them in as well.
And similarly for the state complaint, the options, you can either do it online, you can email it, or you can mail it. Unfortunately, there's not a phone-based complaint system, but that would be with DPOR, as I mentioned. And they have a whole fair housing compliance department that processes and investigates complaints. You can see the address on the slide here where you can send that to.
One thing also that you should know is that if a complaint is filed with HUD, HUD will probably refer the complaint to the Fair Housing Office, DPOR, for investigation. So so if you file something from HUD and you get some sort of correspondence saying we're sending your complaint to the Virginia Fair Housing Office, it's because the Virginia Fair Housing Office has a contract with HUD to take those referrals. So that's just important to know in case you're working with someone who's filed a complaint and that happens. That's why it happens. But it'll still be treated as a federal fair housing complaint. One other thing, there may be good reasons to file with HUD, particularly if the housing provider is getting money from HUD. So in other words, a project-based Section 8 development or a public housing complex, because HUD has authority to investigate certain types of discrimination under other laws. So they will defer the Fair Housing Act component of the complaint to the Virginia Fair Housing Office, but they may separately investigate other complaints under other civil rights laws. So I would generally recommend filing with HUD and then let HUD send it to Virginia, because there may be other, HUD may choose to investigate a piece of the complaint under another civil rights law. And most frequently, this would be disability-related complaints in federally assisted housing. They would investigate under something called Section 504 of the Rehabilitation Act, which is a law that bans discrimination on the basis of handicap by recipients of federal funds. There's a similar law relating to race or color or national origin discrimination, Title VI of the Civil Rights Act, and there too they may choose to keep an investigation under those laws. So how does the complaint process work? So first there's an intake, which is basically completing the paperwork, the complaint form that HUD has. Or you don't necessarily need to use that form. You can write out a complaint and send it off to HUD. But intake refers to the receipt of a complaint. When the complaint is received There'll be some correspondence acknowledging receipt of the complaint. If it's referred to the Virginia Fair Housing Office, that will be mentioned in that letter. And then the next step in the process is that the complaint gets investigated. So HUD or the Virginia Fair Housing Office will, look into the matter. They'll probably ask the person to whom the complaint was made against to respond by, in writing, saying, what do you have to say about this? Is this true? Is this not true? And that's largely what happens at the investigative stage. There may be testing done by the agency. I don't know whether the Virginia Fair Housing Office really does that. I used to work in Rhode Island. Okay, well, that's again, the idea behind the investigation is to develop a factual record to make a determination as to whether there's been a likely violation of the fair housing law. And that in the term for that is a finding of probable cause. So if the investigation concludes with a finding of probable cause, then the next step is to try, the agency will try to get the parties to sit down and come to an agreement to get the violator into compliance with the law. So in other words, it's like to try to settle the complaint. And if conciliation or settlement is not, doesn't happen, then the complaint is referred to some further legal action, which may include some sort of hearing in front of an administrative law judge or the filing of a case in the court system.
And whether you choose to do an administrative complaint or file a lawsuit, they're not mutually exclusive. We don't go into a lot of detail or any detail about how to file a lawsuit. That's where you would want to reach out to an attorney to assist you. But let's say you've filed a complaint alleging a fair housing violation. In the meantime, the landlord is threatening to evict you. At that point, it might be wise to go ahead and file a lawsuit and seek, a preliminary injunction to stop the landlord from evicting you. So there could be a reason for doing one or the other or both.
Now, legal aid programs do that kind of work. They may not have resources at the time that you come in with a complaint, but most of the legal aid offices in Virginia will, do fair housing work, but whether they have the resources to take on a particular case will depend on, factors unrelated to the merits of the actual complaint.
So that's all we have for you today. Were there any questions?
I have a few questions, and I should have written them down. Going back to, I was the one that asked about my name is Bert. Hi, how are you? I asked about the Section 8 and landlords, and I know this for a fact. One of my best friends was a property manager, assistant property manager in a place in Charlottesville, and some of the units were privately owned and some were owned by the business. And they started buying out the privately owned ones because they wanted to do away with Section 8. And because anything owned by the business, you couldn't use Section 8 for. So my question is, but you're saying that landlords who have 4 units or under don't have to go by that law, correct? Is that it? Did I get that right? So they can say, I don't take Section 8 if they only have 4 homes?
Yes, let me double check because I get confused sometimes whether it's 4 or more. I believe it's 4 or fewer.
4 or fewer.
That's
right.
how I think this.
Yeah, okay.
So
yeah.
how would you if I were helping somebody, they don't know how many homes the landlord owns. So how do they know if they're being discriminated against? How would they find out?
So it is on the burden of the person who's claiming exemption. So in this circumstance, it would be the property owner who would have to assert that they're exempt from the Fair Housing Act. I think a good place to start if you're assisting someone is to try to do a property record search to find out how many units they own. But they
And
can
I'm
file
sorry,
a
I'm just to, while you're saying that, does it have to be in a certain city? Because you have some landlords who have, and I've dealt with them because I'm working with a legal aid here with the rent relief. And some of the landlords are in DC or they live in Norfolk, but they have property here. So does it matter where they live?
No.
Okay.
No, and you can still file a fair housing complaint in this case because if it's a source of funds, it's only under the Virginia Fair Housing Act. So you would file a complaint with the Virginia Fair Housing Office in DPOR, and then they will initiate the investigation. In Virginia, once they have that completed intake, they have 30 days to initiate the investigation. And so when they're investigating, they will look to see, is this landlord exempt? Or if you chose to file a lawsuit, let's say you're helping a tenant and they apply for an apartment and the landlord denies them because they have a voucher. You could file that lawsuit in circuit court, and it would be up to that landlord to assert the defense that, oh, this doesn't apply to me because I only owe this number of properties, and they would have to have some sort of proof showing that they're exempt.
Okay.
I think the tricky part that some voucher holders run into is that a landlord could deny that applicant for other reasons. So if the landlord has requirements like we don't take people who have an eviction in the past 5 years, or if their credit scores below a certain amount, that unfortunately is a lawful reason to deny an applicant. However, that policy has to be applied the same across all applicants. They can't have a special criteria just for people who have a voucher.
So how does this, because I live there personally myself, and I'm not going to name, but this property, and I know they deliberately started buying out these units to get rid of Section 8 vouchers and the people who had Section 8. So how are they getting away with that though? And I mean, and they were pretty blatant about it.
Because no one filed a complaint. I mean, the Fair Housing Office and HUD don't just like, police like police officers do. They're not roaming the streets looking for fair housing violations. So someone has to bring a potential fair housing violation to the attention of HUD or the Fair Housing Office. And if no one does it, then they get away with it.
All right, thank you.
It is rather infuriating. I mentioned when Steve was talking about the investigation and the question of whether or not they use testers. I know under the previous Attorney General, they received complaints of source of funds violations of housing providers who were not accepting voucher holders. And so it got referred over, and they hired investigators to test in particular areas. It wasn't across all of the state. I think it was mostly in Richmond and Central Virginia to get records of instances of violations. And then they actually
just so you know, Charlottesville is, because that's where I'm talking about, is big for that.
Oh, I'm
very
sure.
big for that.
Yes.
I'm sure it's not alone.
Yes. Yeah, I don't know if they did any testing in Charlottesville. I think it was mostly in the Richmond area. And they did bring stuff against a number of landlords in the Richmond area. But I don't know that they've done anything since then. The nice thing about filing a complaint is that if a tenant is like nervous or worried about retaliation, even though that's itself is a violation, they can still do that complaint anonymously, and then the Fair Housing Office can conduct their own investigation, do things like hiring testers to find that violation, which is how they got these source of funds cases. I was hoping that with the new Attorney General's office that we would be seeing more of these cases, because until we start to have enforcement of this new law, we're going to continue to see discrimination and landlords denying voucher holders.
And how about the way they're raising rent? Because I know that rent is being raised so much in so many areas. And Charlottesville is a perfect example. I moved to Virginia Beach, is where I live now, or moved back to Virginia Beach. And when I first moved to Charlottesville, all I could think was the rent there was almost like New York prices, Manhattan prices, and it's not a big city. And then the rents just kept going up and up and up. So it's almost impossible for someone to afford a place there. So there's no limitation on how much a landlord can raise the rent in an area?
Not in Virginia. We do not have any sort of rent caps or anything of that nature. And unfortunately, even the retaliation protections are pretty weak. So it would be retaliation if a tenant is trying to enforce their fair housing rights and the landlord knows about it. And enforcing could be anything from filing a complaint, filing a lawsuit, being a witness in the lawsuit against the landlord. Now, if the landlord turns around and just raises the rent against that one tenant, it might be a violation. However, they're allowed to raise the rent to the quote unquote market rates, which over the past year, I think the national average is rents have gone up something like 20%. It is just absolutely insane. Until we get some sort of protections to cap the amount that a landlord can raise the rent from year to year, they can just keep making it just astronomically expensive for people. Assuming that they're doing it for everyone the same across the board.
All right, thank you.
You're welcome.
This is Sally Mae. Thank you. Thank you very much. Thank you. I need to go right now. I need to get into bed and rest myself, but I appreciate you. Thank you so much. And thank you
so much.
interpreters as well. I appreciate you guys.
Thank you
very
so much for coming.
Good night.
Thank you. Yes, that was wonderful. Thank you.
Thank you. And
Thank
if any
you.
questions come up, you're always welcome to email myself or Steve. I'll put our emails in the chat. And in the next few days, I will work on getting a recording of this presentation put up onto our YouTube channel and share it with everyone. So if you know people who wanted to come but they missed it, or if you want to review, feel free to share that with them.
Thank you.
Thank you so much. Have a good night, everyone.
Yep.
Good
Thank you.
night.
Take care.